This is the Oscar Pistorius trial channel, Carte Blanche channel. Welcome back. It's our legal roundtable. It's that part of the show where we have a look at some of the social media questions that have come up, and I think we've got some beauties here. I've got all our experts standing by. And our first question was on a complex legal issue. I've asked the panel who can do the concept of dolus eventualis in 1 minute, and James, you volunteered 3 sentences. Go for it.
3 sentences. Every pregnancy, if you take dolus eventualis, every pregnancy is a planned pregnancy, because everybody knows what they're doing when they engage in coitus. You foresee the possibility that that may result in a child, and nonetheless you continue. And therefore every pregnancy is a planned pregnancy. That's the same as dolus eventualis. You foresee the possibility that a certain set of circumstances may occur, and nonetheless you proceed.
You still go ahead.
You still go ahead and do it. Every pregnancy is a planned pregnancy.
Well, I think there's one reason possibly why dolus eventualis isn't at the heart of this case is it's not so much about foresight. I don't think there's much doubt that Mr. Pistorius intended to shoot whoever was behind the door, and that is a clear feature of the case. So it does deal with a direct intention to fire at whoever was behind the door, and that's really about direct intent rather than foresight of a particular result.
Okay, Chris?
And just to add on to what my esteemed colleague has said here, that type of question only arises after all the evidence.
Yes.
In other words, when the judge says to Gerinel, have you proved your case? Then he's got all these options. He can say, I've proved actual intent. I've proved premeditated murder. I've proved dolus eventualis or dolus directus or dolus indirectus. Those are all the options. It only arises at the end of the case in the light of the evidence, in the light of what's been proved.
And also I think tellingly is also only after Mr. Pistorius has testified as well. I think that aspect will only come up then.
Okay, I hope that explains that. Just go with James's pregnancy analogy. How does the role of the advocate differ from the role of the attorney in the criminal case? Well, just for people who are watching regularly, you'll find the attorney is actually sitting behind, Brian Webber sits behind Barry Rue. He's got his co-counsel, Kenny Olwich, next to him. But David, can you take that one? The role of the advocate versus the role of the attorney?
In the traditional system, the attorney instructs the advocate, and it's the advocate who does the work in court in the sense of actually addressing the court and cross-examining the witnesses. But some of these distinctions have started to change quite considerably because many attorneys run criminal trials themselves and they have the right to do so. But in this case, it's being run on a slightly more traditional basis, which is that the attorney helps to prepare the case and supports the advocate who does the actual presentation of the case in court.
Yes, Chris?
And the life of an advocate traditionally is much better than an attorney. Advocates traditionally didn't see clients. They don't answer the phone. What happens? What happens is that
was still true.
what happens is that the advocate sits in his chambers and he waits for a brief. In other words, he gets documentation in a nice red ribbon.
That's right.
In which all the work has been done and a specific issue is put to the advocate to resolve. And this often, as my esteemed colleague has said, involves the advocate then taking that to court. And he might only see the client for 15 minutes. It's a wonderful life. You act like a specialist. Yeah. You're only called into the operating theatre.
Are you one of those attorneys, James, that you also appear in court?
Yes, I do all my own work. If I have to brief counsel, it's an absolute last resort. Yeah.
Okay, let's go to the next one. If Oscar Pistorius had a jury, this case would have gone a hell of a lot differently. Why don't we have juries? Helen, you want to take the issue of juries? Why don't we have juries?
Okay, in the past, if you look at our legal system, we had juries in the past, but that was abolished. Yeah, so what we have now, we have a trier of fact, is what we call them, a judge. So in this particular case, you see that it's a judge with 2 assessors. So those people are also learned. Most of them are attorneys, advocates. So they are there to help the judge in assessing the facts.
There's an interesting historical footnote on this, which is that the idea of the jury is that you are judged by your peers, and that's the idea of the jury system. The jury system was abolished in this country because of our racist past. What was happening is that white juries were constantly finding black accused guilty, and it became absolutely politically untenable to maintain the system, and so they changed it, and it's never come back. Some people think we should have it back, but we don't.
And also my understanding was that there was a further issue was that the people, in terms terms of how you qualified for the jury, it disqualified black people from, so your juries would always be white.
Exactly. There was a whole racist overlay to it, and that's why it went.
Yeah, Chris?
I think most social scientists will tell you that it's almost impossible to have a jury system in a multiracial, multicultural society like South Africa, especially because of the apartheid past. It just won't work. Just one other thing about the judge and assessors. I think it's important to point out to the public that even if the assessors are legally qualified, the judge alone makes decisions on issues of law. For instance, these applications as to how much can be streamed and what evidence, the judge will make those determinations.
She won't defer to the assessors on that.
The assessors only help the judge on issues of fact.
Right.
What were the facts of the matter?
James, you had something to say as
Just
well?
one last thing on the jury system. The fact is this: when you have judges and seasoned magistrates, those are people that have been studying for years upon years upon years, have been practicing for years upon years upon years. So those people are extremely learned and have dealt with the law their whole lives. Whereas if you had a jury system, you're just going to have 12 people ad hoc brought on to make a decision on a person's livelihood, their lifestyle, their freedom at the end of the day.
Can I offer a different view? I'm probably the only person at this table who believes in the jury system.
Oh, okay. No, I'm glad to hear this. Go for it.
Which is that I actually think it's a very fundamental part of a justice system, that it is something where you are finally judged by your peers. I think it's actually a very important way of democratizing the justice system, so it isn't only the preserve of the experts and all the learned people, but ordinary people can be very discerning on questions of fact as to what makes sense and what doesn't. And that's why jury systems have often been very successful. But it's a controversial issue and not one that we have.
And it's fired Chris up here. I can see this. Go on, Chris.
So I want to challenge
Please do.
the learned counsel here. These are the facts. Eugene de Blanche is caught speeding away from a scene in which President Jacob Zuma has just been shot. And when he is grabbed, he lies about. The truth of the matter is that he's been with somebody's wife, but he lies about it. He's caught out in that lie. There are all kinds of reasons to suppose, imagine, and presume that he is responsible for the killing. Tell me, what jury are you going to have in South Africa to try Eugene de Blanche on those facts, especially if he's caught out in his lie?
Well, I would put it, looking at this particular situation, we're going to try and find 12 people, I'm presuming that's the jury number, who are able to appreciate the legalities and the questions of fact in this matter. So we're talking about people with a certain level of intelligence who have not formed an opinion of Oscar Pistorius. I think it would be very hard to find somebody like that.
Well, there are always questions around how do you sequester a jury, but in jury systems what happens is that once the jury is selected, they actually have to live in isolation from this great media attention and all the commentary of the kind that we are offering so that they can come to their own view. I just happen to believe that common sense is something that many, in fact all people have, and they can apply it in quite a sophisticated way, even in complex cases. But I know my views are not widely shared.
You have a fabulously optimistic view of your fellow human being, and I applaud you for that. Do we have another question? Does the state only have use of government employees as experts, or can they use additional outside professionals? Who wants to take that one? Anybody?
I've actually never come across a private individual. Most of the people are in the service of the state. And I suppose they could hire an outside expert. There's nothing precluding them from doing that. But most people most of the experts are hired by the state because it's so common cause.
I think it's a practical question.
Yeah.
If you've got in-house expertise, you'll use it. But if you had a highly specialized point of expert testimony and you didn't have the right expert, you're not going to put up somebody who you don't think is up to the job. You'd hire an outside expert.
So it's not a hard and fast thing. And then finally, what's the difference between the different oaths Vermeulen could have taken? That was because he decided to affirm rather than to swear. David, you want to take that one?
It's really just simply this. Some people believe in God and others don't. For those who believe in God, you can swear to tell the truth by an appeal to God and on the Bible or the Quran. If you don't believe in God, you must nevertheless say that you will tell the truth, but you affirm that you will do so as a matter of your own honor and integrity, not by reference to your belief in God. And it just marks out the difference between whether people do or don't believe in God.
And it was as simple as that.
I think the court just has to be satisfied that you have bound your conscience.
Yeah.
Okay.
Also warned to
That's
tell
all.
the truth. That's, I think, the initial point of it, that the court warns you to tell the truth.
And your conscience may reverberate through religious sentiments and beliefs, and sometimes your conscience is just a question of your own integrity, but it's just a different way of trying to get to the same point.
And might not exist at all.
Well, at that point, we'll have to wrap up. It's been a fascinating debate, as it always is. My thanks to you, Chris, David, Helen, James, and look forward to seeing you again. And my thanks to our experts for their insights, their participation, and we'll have more debate from the round table tomorrow evening at 8 p.m. Until then, stay in touch with me via @OscarTrial199, where you can send us the questions that you'd like our legal panel to address. Remember, if you're not, and when you're not in front of your TV, that Channel 199 is available online to qualifying DSTV subscribers. The full channel is available 24/7 via live streaming to PCs and laptops at OscarTrial.com, and therefore also available on your walker. Up now, Katie Catapodis, good night from me.